and there's no cause for alarm. Sometimes there's too much, and I think it's also healthy. It's part of our democracy, the freedom of expression. So people, the media, at liberty to sometimes, when you offer some certain advice, and they think that that may not have been taken, they think, oh, this is now war. No, it isn't. So I think that perhaps may explain some of the difficulties that we are having. And I'm sorry that I think I spoke too much. I forgot the Vice Chair and asked this issue about independence. And it's good that the Honorable Makali has raised it again. And I think a few other members who have spoken to it. First is to appreciate that Chapter 15 of our Constitution is the one that deals with the constitutional commissions and independent offices. So, strictly speaking, there are only two independent offices if you go to Chapter 15. That is the Auditor General and the Controller of Budget. So these are the notion, merely because there is a usage of a word independent in the Constitution, does not create that as an independent office, as understood in the Constitution. In fact, I think it's Article 248. It explains what are the independent offices. So there are only those two. So the mere usage of the word that the DPP shall be independent, it shall not be subject to any other authority. But it is in making the decisions that is charging so and so. It's prosecuting and go to charge so and so. That is the level of the independence that is required there. On the other hand, if you look at Article 156, it also says, I know it's more or less similar to what is in 157, because the functions of the DPP to prosecute are exercised also by officers subordinate to him. And the same is to be found in Article 156 with regard to the exercise of the functions and the powers of the Attorney General, exercised by the Solicitor General. If you go to Section 6 of the OAG Act, you see that there is that delegation is provided for in the Act, both to the Solicitor General and the other state councils, either specifically or generally. When they do what they do, be it to appear in court, surely they do it purely on the basis of the law and the evidence available. They also exercise independence. When we give and we are designated as the principal legal advisor to government, in giving that advice, we do not consult another person in government. Perhaps, of course, I've spoken to some people and they tell me, what do you think yourself? I said, no, I've come to ask you because you are the expert in this area. What you tell me is I'll make a decision. For me, my position is, as principal legal advisor to government, on the basis of the law and the Constitution, it doesn't matter what anybody feels, we state them and we do so in writing. So that when I attend meetings, and the chairman raised the issue of me attending in cabinet, when I attend meetings, I'm merely in attendance. That time I'm not advising. And I've told everybody who cares to listen that, here we are in a meeting. When you want advice, please write so that you say specifically what it is you want to be advised on. So that it cannot be that everywhere people are attending a marriage ceremony, I'm advising there. No. And I'm sure you may have noticed that I'm not feasible in such functions because there's no work for me there. If we go, we maybe just go to dance and maybe eat and drink, enjoy with everybody. When it is advised, it is independent. Indeed, when we are also reviewing international agreements and treaties and conventions, we have to do it purely on the basis of what is in the best interest of Kenya, as reflected in our constitution. Because again, there are certain things that we may not agree with because they are not in consonance with our constitutional provisions. So, Honorable Makali, Honorable Vice Chair, I think that this independence is to be exercised by all the offices, but more particularly, given the peculiar nature of the office that the AG occupies, you cannot do it otherwise than independently. Same way that the DPP does their work. Indeed, if we were to tie that with what is in Article 152, again, you see that it establishes the cabinet and provides very clearly that the cabinet shall consist of the president, A, deputy president, B, the attorney general, C, D, not fewer than 14 and not more than 22 cabinet secretaries. I think, again, that is also deliberate. And I think I thank the people who are doing the constitution, one of who is sitting right in front of me, Senior Counsel Otiende Amolo, because they were able to clearly provide for that. Otherwise, the Attorney General has been treated in the past as a cabinet minister. In fact, on occasion, I've had people, I have attended some functions, and they say cabinet secretaries to stand. I just look at them. I continue sitting because I'm not one such. Yeah? It's just so that people may begin to understand that we are not, I'm not a cabinet secretary. In fact, in 2018, I think some of you, I'm sure many of you will recall, the Law Society went to court when the former president attempted to assign the former Attorney General, Professor Githu Muigai, some responsibility of a cabinet secretary. And the Law Society said, no, he's not a cabinet secretary. Why are you giving him this? And the court upheld that objection, that the AG is not a cabinet secretary. In fact, that's why you see even the office is conveniently styled Office of the Attorney General and Department of Justice, because we cannot perform ministerial work. I hope I've been able to persuade my friend, Honorable.
So is it your case that then the Public Service Commission is for departments that are led by cabinet secretaries, and the Office of the Attorney General is not one of such, and therefore there is justification for it to be given independence away from PSC based on that legal reasoning?
Indeed, Honorable Vice Chair. And in fact, if I may go to Section 21, just to read it to put it in perspective. The Attorney General may, in consultation with and on the recommendations of the Public Service Commission, appoint such number of state counsel as may be necessary for the proper and efficient discharge of the functions of the office. So who is to determine the number is the AG. But what they have done, the example I gave you of the meeting of 21st, because I think my predecessors continued in the old mold that they were part of the entire public service. They continued pleading with the Public Service Commission. Now, here it is in consultation. If you ask me, the meeting they held on 11th of March 2020 That was the consultation. If anything else was to happen, and they say, you need to appoint so many, you have indicated to us you have a shortage of this much. It was for the AG to determine that you are going to appoint this number. Because you are the one given the responsibility to determine the number and what is it for the proper and efficient discharge of the functions, some of which are, as I was saying, civil litigation, international law division, public trustee, registrar general's department, and several of those ones. Many of which, some of them, of course, are not even public facing. Of course, marriages, registrar societies, and business registration services is public facing and maybe civil litigation to an extent. But no, many of the other functions that we perform are actually not public facing, like legal advisory, international law, except when now we have to advance this to come to Parliament. Many of them are really quite in-house things, inward-looking, because the advisory is to only one client, the government. The AG is also, if you go to Article 156, you see the AG is provided to be the defender of public interest. And decisions have been made by various courts in this country where people have wanted to be enjoined in suits, and they are told, no, why don't you go and seek the involvement of the Attorney General? Again, when you're doing those things, you can only do so because you determine what is optimal. What are the kind of services you want to offer? Even the deployment of state counsel is a function given to the Attorney General. Now,
Bonaiji,
yes, Adam.
The Vice Chair asked a question about your quasi-independence using the composition of the cabinet, where the AG is. But then, will that not be the same for the President and the Deputy President? So the office of the President and the office of the Deputy President will not be officers under the power. Officers working in those offices will not be subject to Public Service Commission.
No, that's not the reason. That's not the reason. I'm not saying that because of the classification. It is purely because of the nature of services. These are legal services. And look at, if the AG in this country was also doubling as the public prosecutor, and that has happened for the longest time in our history. And we found it necessary to separate these roles. And I think for good measure. I'm one of those people who campaigned for that thing to happen, because it was good that the AG, the AG does not do the public prosecution in criminal matters. But because you offer same services, you actually employ the same people. They have gone the same training. Now, when it comes to what is it that you want, you go to Public Service Commission, you tell them, they tell you, no, this is your establishment. They tell them, okay, fine, we think these are people that have performed so well. They tell you, no. In fact, unlike what happens when the President is given names of principal secretaries, a host of names to select from. In the case of the recruitment done by the Public Service Commission for the staff of the Office of the Attorney General, they don't give the AG that we have interviewed this, we think you can pick now any. Of course, if something like that was happening, perhaps you can say that now the AG is exercising that power to appoint under Section 21. But it doesn't happen that way. The Public Service Commission will interview a host of people. They will pick and tell you. In fact, they will write letters to the AG and a copy to the Principal Secretary, Ministry of Public Service. They have already employed. So actually, there is no work for, there is no, this provision in this act is dead.
Good. I believe
Maybe just, sorry, Chair, just I want to be clear in my mind. Maybe, sorry, Honorable AG. It'd be right to say that this amendment is actually